You know that moment in a courtroom drama? The one where the lawyer is pacing, the witness is sweating, and a single sharp question changes everything? That's cross-examination. It's where cases can be won or lost. But how does it really work? What are the rules of this high-stakes game? Well, let's pull back the curtain and find out.
And this line, it just nails it. This is the central tension of cross-examination. See, it's not really about just getting information. It's a performance. It's advocacy. The lawyer is telling a story, they're making an argument, and they're guiding everyone to their version of the truth, all while technically just asking questions. It's an art form, really.
So, how do they do it? What's the secret? Well, their number one tool, their secret weapon, is something called a leading question. And once you get this, the whole strategy of cross-examination just clicks into place. Okay, so a leading question isn't, "What did you see that night?" It's, "You saw the red car run the stop sign, didn't you?" See the difference? The answer is already baked right into the question. The lawyer's basically testifying for the witness, and all they need is a simple yes or no.
But here's where it gets really interesting. It all comes down to context. When a lawyer is questioning their own witness, someone who's on their side, that's called examination in chief. And you cannot use leading questions then. I mean, that would be like feeding them their lines, right? But when you're questioning the other side's witness, someone who's hostile to your case, then leading questions are totally fair game. Because the goal isn't to hear their story. The goal is to test it, to challenge it, and to poke holes in it.
But it's not a total free-for-all. There are still some pretty important rules. A lawyer can't just ask, "Why were you driving so fast?" if the witness hasn't even admitted they were speeding. That's a huge no-no. It assumes a fact that's not even proven yet. And there's a huge strategic trap here, too. If a lawyer starts leading a witness who is supposedly on their side, it can backfire big time. It starts to look like they're in cahoots, and a judge or jury might just decide that testimony isn't credible at all. Okay, so we've got the what of the questions down, but that's only half the story. Now for the who. Who actually has to get up there and face this kind of grilling? So the basic rule is pretty simple. If you take the stand to testify, you are fair game for the other side to question you. It's a fundamental part of a fair trial. But you know there have to be exceptions, right? And there are a couple of really interesting ones. And these exceptions, they just make sense. First, if someone is only there to hand over a document, like an expert handing over a report, and they don't say a word, they can't be cross-examined. Second, if a lawyer makes a genuine oops and calls the wrong person to the stand, they can withdraw them without the other side getting a free shot. And that first one, the document rule, it's actually been around for ages. As Sergeant Ludlow pointed out way back when, not having this rule would cause the greatest mischief. Basically, it stops a lawyer from playing a dirty trick, forcing their opponent to call a hostile witness just to get a piece of paper into evidence. It prevents a sneaky procedural trap. The second exception is all about basic fairness. A real mistake shouldn't be weaponized. As Justice Coleridge put it, the other side ought not to have the right to take advantage of an honest error. Now, if a lawyer suddenly realizes their witness is about to sink their case and tries to pull them, nope, the court sees right through that. This rule is for genuine slip-ups only.
Okay, so we know who's in the hot seat, but who gets to light the fire? Let's flip this around and look at who gets to ask the questions, because trust me, the answer isn't always who you'd expect.
Okay, picture this. You've got two people on trial for the exact same crime. They're co-defendants, sitting at the same table. One of them decides to take the stand to testify in their own defense. Now here's the question. Can the other defendant's lawyer stand up and start cross-examining them? The answer is a clear, powerful, and absolute yes. And the reason why really gets to the very heart of what a fair trial is all about. I mean, think about it. Your right to a fair trial means you have the right to defend yourself against any testimony that hurts your case. So if the person on trial with you says something that points the finger your way or totally contradicts your alibi, you absolutely have the right to challenge them on it. Any other rule just wouldn't be fair. And the legal rulebook is full of other little quirks like that. For instance, get this, you can actually end up cross-examining a witness you called to the stand earlier in the trial. Or if someone submits a sworn written statement, an affidavit, they can be grilled on it even if their lawyer tries to take it back. And just to keep things from turning into a total circus, it's usually just one lawyer per party who gets to question each witness.
But what happens when this whole carefully structured process just breaks? What if a witness starts testifying but for whatever reason can't finish their cross-examination? Does all their evidence just get thrown out?
So what happens?
Well, if a witness gets sick halfway through, their testimony doesn't just get wiped from the record. It's still admissible, but the judge will tell the jury, hey, be careful with this, it wasn't fully tested, so it might carry less weight. Same goes for a written statement from someone who has since passed away. It's allowed in, but it comes with a giant asterisk. And in the very sensitive case of a child who can't answer, a judge has to make a tough call, which might mean giving a really strong warning to the jury about relying on that untested evidence.
So the big takeaway here is that courts really don't like just erasing testimony. The modern approach is to trust the judge or jury to be smart about it, to let the evidence in, but to weigh it for what it's worth, warts and all. The goal is to figure out its value, not to pretend it was never heard in the first place.
Which kind of brings us full circle, doesn't it? After seeing the rules, the strategies, and what happens when it all falls apart, what do you think? Is cross-examination a finely tuned machine for discovering the truth? Or is it simply a performance, that speech thrown into the form of questions, where the best advocate, not necessarily the truth, wins the day? The reality, as we've seen, is somewhere in that very complicated and very fascinating middle.